for being here. It's great to be with such a big crowd this morning. An unruly crowd, I might say. If I would whistle, I would, but I can't, so. My name's Rachel Brand. I'm the chairman of the Federalist Society's Litigation Practice Group, which organized and is sponsoring the panel discussion you're about to hear. My first job this morning is to put a plug in for the Federalist Society's practice groups. I know that oftentimes folks who have been involved in the Federalist Society for many years, can we do something about that? Don't realize that much of the content that the Federalist Society puts together is organized by volunteers like me who serve on the executive committees of the various practice groups. We are always looking for more help, so if you are looking for a way to get involved, please come find me afterwards, or look for Dean Reuter, who's here at the head table, who is the vice president in charge of the practice groups. With that out of the way, I'm delighted to introduce our panel discussion today. The subject of this panel is Justice Scalia's writing style and its impact on jurisprudence. Justice Alito talked eloquently about that this morning, and we could not have a better group of people here to bring their personal and professional perspectives to that subject. Justice Joan Larson will introduce the panelists and will facilitate the discussion. Our moderator has a very impressive resume prior to taking the bench, which spanned private practice, where she was a litigator at Sidley Austin. It spanned public service, where she was a Deputy Assistant Attorney General in the Office of Legal Counsel in the Bush administration, and academia. She was a law professor at University of Michigan Law School. Governor Snyder appointed her last year to the Michigan Supreme Court, and she just won her retention election last week. So congratulations and thank you for being here.
Thank you, Rachel, and welcome everyone to this panel on how Justice Scalia's writing style affected American jurisprudence. Thank you to the Federalist Society, as always, for putting on a wonderful conference and for inviting me to be a part of it. I moderated a panel at this convention last year, only about a month after being appointed to the Michigan Supreme Court. The topic was Labor and Employment, the 80th anniversary of the National Labor Relations Act and congressional action. And although the discussion was educational and lively, for those of you who are veterans of Federalist Society conventions, you know that no panel that has Richard Epstein on it can be anything other than lively. I will be the first to admit that labor law is not my area of expertise. Today's panel is much more personal to me. Like many of today's panelists, I was fortunate to have served as a law clerk to Justice Scalia. What he taught me about the law, about judging, and about my native tongue cannot be captured in just a few words here. I can only say that I am so grateful for having had the opportunity to learn from him, to work for him, and to know him. But the reach of Justice Scalia's influence was not limited to his clerks. Otherwise, we would not be here having an entire convention devoted to his legacy. Justice Scalia was the standard bearer for an approach to judging based on textualism and judicial restraint. His opinions, books, and speeches have helped countless judges throughout the country understand the art of interpreting texts and the limited but important role of the judiciary in our constitutional democracy. This panel is focused on a subtle aspect of Justice Scalia's influence, his writing style. Justice Scalia's opinions were elegant, often pointed, and thoroughly enjoyable to read. I am sure that everyone at this convention has a favorite Scalia quote. Mine, from his lone dissent in Morrison versus Olson, warned the reader that not all dangers come disguised in sheep's clothing. This wolf, he told us, comes as a wolf. Justice Scalia's prose was masterful, not only because he could turn a clever phrase, but because it was so accessible. Anyone, lawyer or layman alike, can read a Scalia opinion and understand what it says. His writing was precise, careful, and accessible because he believed that the greatest check, perhaps the only effective check on an insulated judiciary was the duty of the judges to explain themselves to the people in writing. I am confident that I speak for all of his former clerks when I say that when I write, I still write for him. And with that, I would like to briefly introduce our panel. I will only give a brief introduction. All of you have the full biographies of our esteemed panel in your folios or in the online app. We'll hear from each of our speakers for about 10 minutes, and then we'll give them the opportunity to briefly respond to each other. And after that, we'll open the floor for questions with whatever time remains. Our first panelist, Canon Shanmugam, is a partner at the law firm of Williams & Connolly in Washington. He is the head of the firm's Supreme Court and appellate litigation practice and is widely recognized as one of the nation's premier appellate advocates. He has argued more than 18 cases before the United States Supreme Court. Prior to joining Williams & Connolly, Canon served as an assistant to the Solicitor General in the Department of Justice. Canon served as a law clerk to Justice Scalia after serving as a law clerk to Judge Mike Ludig on the U.S. Court of Appeals for the Fourth Circuit. Our next panelist will be Brian Fitzpatrick. Brian is professor of law at Vanderbilt University. He focuses his research on class action litigation, federal courts, judicial selection, and constitutional law. After graduating first in his class from Harvard Law School, Professor Fitzpatrick clerked for Judge O'Scanlan on the U.S. Court of Appeals for the Ninth Circuit, and then for Justice Scalia. Before entering the academy, Professor Fitzpatrick practiced law at my law firm alma mater, Sidley Austin. After Professor Fitzpatrick speaks, we will hear from another distinguished professor, Professor Toni Massaro. She is Regents Professor, the Milton O. Ripe Chair in Constitutional Law, and Dean Emerita of the James E. Rogers College of Law at the University of Arizona. Prior to joining the faculty, Professor Massaro practiced law with the law firm of Vedder Price in Chicago. She has taught not only at Arizona, but also at Washington and Lee University, Stanford University, UNC Chapel Hill, and the University of Florida. A prolific author, she has penned many books and articles on the subject of constitutional law, which are listed in her full biography, which is available to you. And our last panelist is the Honorable Jeffrey Sutton. He is a judge for the U.S. Court of Appeals for the Sixth Circuit. He graduated from Williams College and from the Ohio State University College of Law, or as we Michiganders like to call it, that school down south. Judge Sutton began his legal career as a law clerk, both to Justice Lewis Powell and to Justice Scalia. Before assuming the bench, he served as state solicitor of Ohio and as a partner with the law firm of Jones Day, Rivas, and Pogue. Despite this full resume, Judge Sutton finds time to teach, serving as an adjunct professor at the aforementioned school down south, as well as teaching a class on state constitutional law at Harvard Law School. We are thrilled to have such a distinguished panel, and I will now turn it over to Canon Shanmugam.
Well, thank you, Justice Larson, and it's always great to have the opportunity to speak to the Federalist Society, but it's a particular honor this year to speak to the Lawyers Convention on a subject that is so near and dear to my heart, and I know to the hearts of my co-panelists, Justice Scalia's writing. I want to start where Justice Larson left off. In those terrible days after Justice Scalia's passing, I remember attending his wake, and at that wake, running into Justice Kagan. And we talked, of course, about the justice, and we turned to the subject of the justice's influence on each of us. And we both agreed that when we wrote in our respective roles, we both wrote in some sense for Justice Scalia. Justice Kagan used a line when we talked that she later used in her tribute in the Harvard Law Review. She said that when she wrote opinions, she wrote with an image of Justice Scalia sitting on her shoulder. That's a vivid image, to be sure. I think she said it was a little Justice Scalia sitting on her shoulder. But she said that even when she knew that the justice was going to disagree, he was in some sense her intended audience. And when she said that, I remember thinking to myself, when I write briefs for the Supreme Court, I feel exactly the same way. Even in cases where I know that I'm going to have Justice Scalia's vote on my side, he was in some sense always on my mind as the target audience. And I think that that was because all of us really wanted to live up to his reputation as a writer. And while it would be impossible to write briefs like Justice Scalia wrote opinions, I think that he set a standard for jurists and lawyers alike in the way that he wrote opinions. Now, I think in many ways, some of Justice Scalia's critics in the months since his death have tried to throw a little shade on him when they talk about his writing. They say that, he was just such a great writer, he had such force of personality, as if he was somehow able through that great writing to convince unwitting readers to agree with his writing when they really shouldn't. And I think with all due respect that is simply not correct. The reason in my mind why he was a great writer was precisely because he was a great legal thinker. Much will be said and has been said already over these 3 days about his jurisprudence, about his coherent approach to judging, to constitutional and statutory interpretation. But I think above all, Justice Scalia was a relentlessly logical legal thinker. He was the king of the syllogism. And I would encourage you not only to read his great opinions like his dissent in Morrison versus Olson, but to pick up an opinion in an otherwise unremarkable case, and at the risk of offending certain lawyers in the room, to pick up an ERISA opinion or a bankruptcy opinion, and to see that relentless logical mind at work. And while there may have been more lyrical writers in the court's history, there were certainly no clearer ones. I think some say that Justice Scalia was one of the court's greatest justices because he was one of the court's greatest writers, and I think that gets it exactly backwards. He was one of the court's greatest writers because he was one of the court's greatest justices, and his clarity of thought and of reasoning explains in large part why he was such a brilliant writer. I want to say a word about how he wrote, and you'll be hearing about this, I think, over the course of this panel from the many of us who clerked for Justice Scalia. I think that there is a little bit of a misconception that Justice Scalia was so brilliant and that writing came so naturally to him that he could just sort of dash off an opinion and then go play golf or do something else. And that was certainly not true with Justice Scalia. He worked incredibly hard on his writing. And it wasn't that he was sitting in his office trying to come up with those witty turns of phrase. That was not how he went about writing. He was just incredibly careful and diligent. He was a very concise writer. I remember giving him a draft opinion in a case where the court had voted in conference 9-0 to come out in a particular direction, and I think I gave him about a 14-page draft opinion. And he sat on it for days. He was working on it with his door closed, and I was starting to get nervous in the way that 27-year-old law clerks do. And finally, a few days later, he came out with the draft opinion, and he gave it to me, and I said to him, Justice, I was getting a little nervous. It took you such a long time. And he said, yeah, Cannon, that was just because I wanted to get it down to 10 pages. And that was sort of classic Justice Scalia. He really cared about concision in writing and care in writing. Another thing that many of you will have heard about was Justice Scalia's practice of booking opinions. And Justice Scalia would sit down with his law clerks when the draft opinion was almost finished. He would have the Supreme Court Library put together a cart with all of the sources cited in the opinion, and he would go through the opinion with the law clerk line by line from beginning to end. And that was a process that could often take a couple of days if you had a particularly complicated opinion. And as I wrote in my tribute to Justice Scalia in the Journal of Supreme Court History, it felt a lot like a graduate dissertation defense as the law clerk, because you would be sitting there and Justice Scalia would go through line by line and he would say, why did you cite this source, or why did you characterize this source in a particular way? and he would often tweak the opinion or come up with new ideas as he was going through that process. And he would do that regardless of how high profile the case was, whether it was a case of great constitutional magnitude or an otherwise unremarkable case on ERISA, bankruptcy, and the like. Justice Scalia was someone who really loved to write, and I think anyone who reads one of his opinions can't help but be left with the sense that this was somebody who loved the craft of writing. Though I will also tell you that one of Justice Scalia's favorite aphorisms was Hemingway's famous line about how he didn't enjoy writing, he enjoyed having written. And I think in part that was because the justice did really labor at it. He would go through drafts and edit and edit and edit. And so much of what I do in my own writing is what I learned from Justice Scalia in that incredible year. I want to comment very briefly about the Justice's target audience and then tackle just one other issue, and I hope I don't trespass on our time limits when I do this. First of all, I do think that it's important in thinking about Justice Scalia's writing to realize that his target audience was not, the average reader of the Wall Street Journal or, heaven forbid, the New York Times. It was an educated audience. It was an audience that knew something about the law. He did not treat his audience lightly. He assumed that you, as a reader, were someone who knew what he was talking about. He assumed, I think to some extent, a legal audience. And while I'm sure that he knew with almost biblical certainty that certain lines he included in draft opinions would appear in every newspaper in the country the next morning, see such great lines as pure applesauce, a wolf comes as a wolf, and the like, I don't think he wrote with that audience in mind. And he was a pretty harsh critic of informality in legal writing. As I was preparing to be here today, I went back and looked at his book on practicing law, his book on the art of advocacy. And in the section where he and his co-author, Brian Garner, debated whether it is ever appropriate for judges to use contractions in opinions, Justice Scalia said, "Of course you don't use contractions. Formality bespeaks dignity." And I think that that really did reflect his approach to legal writing. And while he was certainly not averse to using words from the common lexicon and even on occasion the common Scottish lexicon, he, again, took the art of writing for the United States reports very seriously. And I think in that regard, I think he somewhat differed from other judges, many of whom are great writers, but who do write in a somewhat more conversational style. I have just a couple of minutes left, and I want to tackle head-on what I think is probably the most common refrain among critics of Justice Scalia's writing. And those critics, of course, focus on the tone of his opinions. Justice Scalia, when he was interviewed by Leslie Stahl for 60 Minutes in what I think was probably the most insightful television interview he ever did, said that his general attitude towards writing opinions was that he attacked ideas and he did not attack people. And I think it is fair to say that Justice Scalia had some opinions that came pretty close to that line. Justice Scalia was so passionate about the law that, particularly when it was an issue on which he felt very deeply, he could obviously write in very strong and often occasionally trenchant terms. But I think what bothered Justice Scalia about opinions with which he disagreed was not the personality of the justices or even their motives in reaching a particular result. It was, what bothered him, I think, the most was when he saw examples of nonlinear thinking, when he saw examples of rhetoric taking the place of legal reasoning. And I think it's quite telling. If you take a look at perhaps the most famous of his more recent opinions, his dissent in the Obergefell case, there is, of course, the famous footnote in that opinion where he says that if he had ever written an opinion that contained a particular line, rather than joining the opinion, he would hide his head in a bag. And then he goes on to say something that I think is actually very telling. He goes on to say in the last line of the footnote, and many of you will know this by heart, the Supreme Court of the United States has descended from the disciplined legal reasoning of John Marshall and Joseph Story to the mystical aphorisms of the fortune cookie. Now, I am pretty sure that that is the first time in the United States reports that a reference to a fortune cookie ever appeared. But I think what's actually telling about that sentence is that what bothered him was the departure from disciplined legal reasoning. And I think that often if you go back and look at Justice Scalia's harshest opinions in tone, that is what bothers him when the court engages in unmoored balancing, when the court substitutes rhetoric for logic. And I think that that, at least as much and probably more than the outcomes in particular cases, was really what caused Justice Scalia, particularly when dissenting, to be harshly critical. There's so much more that can be said about this subject, but let me just close with one reflection as the active practitioner on this panel. I actually do think that Justice Scalia had an effect on the way that lawyers write. But I don't think, with all due respect to Dean Chemerinsky's criticism of Justice Scalia a couple of years ago, I don't think it's because lawyers try to write like Justice Scalia. Quite frankly, I think that that would be an impossible task. I think that what Justice Scalia has done, and I think his lasting contribution, is to cause practicing lawyers to confront the arguments on the other side, to engage much more directly with the arguments on the other side. And I know that when I write a brief in the Supreme Court and I'm responding to the petitioner or I'm writing a reply brief, I feel very strongly that it's important to say this is the best argument that the other side has, and this is why I think that that argument is wrong. And if you actually go back and read Supreme Court briefs from 20 or 30 years ago, there was much more of a quality of ships passing in the night. And I think that that has dramatically changed. And I think that that's in large part because of Justice Scalia's approach to judging and his approach to writing opinions. And so I think that that really was in large part his lasting legacy from the perspective of a practitioner. There's so much more that could be said on this topic, but we have some wonderful co-panelists here, and so I think at this point I'm just going to sit down and look forward to our further discussion. Thank you all very much.
Thank you all for inviting me to speak to you today about my old boss, Justice Scalia. I approach today's topic, how his writing has influenced American jurisprudence, both as a former law clerk and as someone who saw firsthand how he writes, and I want to share with you some of those observations, memories, and stories that I have from witnessing his actual writing process. But I also approach today's topic as an academic. I teach at Vanderbilt, and academics have both studied the influence of Justice Scalia, and we ourselves are quite influenced by Justice Scalia, and I want to talk to you a little bit about that as well today. I do want to remind us, though, and I'm going to remind us this later on in my presentation as well, that Justice Scalia was not just an author of court opinions. He was a professor before he became a judge, and he has written quite a bit of legal scholarship, and he continued to write legal scholarship after he became a judge. In addition to that, he also was quite a speech maker, and he has delivered dozens upon dozens of speeches, and many of those are written down, and I hope one day will be published, and I'm going to return to that at the very end of my presentation. I want to start, though, by sharing with you some of the academic studies that try to measure how influential Justice Scalia has been. And now when I go through these studies, I do want to offer a caveat, and that is, Justice Scalia was a great writer, but he also had very powerful ideas, and it's very difficult to separate what was doing the most work, the ideas or the writing style. It was a combination of the two. We haven't developed any ways to separate out which was doing most of the work. So when I talk about his influence, some of it's the ideas and some of it's the way he wrote, but he clearly was very influential. For example, academics have tried to discern whether Justice Scalia changed the way his colleagues on the U.S. Supreme Court did their job after he joined the court. And so professors have looked at, scholars have looked at how often Justice Scalia's colleagues were citing to the dictionary when they were doing their statutory interpretation, before he got there and after. And what you see is a huge uptick in the graphs when scholars have counted up dictionary citations by his colleagues before 86 compared to after 86. You see the exact same thing with legislative history. Justice Scalia's colleagues stopped citing legislative history as frequently after he joins the court than before. You see much of these same trends, not just in the U.S. Supreme Court, but in the lower courts, and we might hear some more about that today from Judge Sutton. But Frank Cross, who's a political scientist at the University of Texas, did a terrific study of how often lower court judges cited opinions that were written by each of the U.S. Supreme Court justices. And I'll just, the best way for me to tell you what Frank Cross's findings were is to read to you the subtitle of his article that he wrote. His article was subtitled, "The Remarkable Influence of Justice Scalia." Justice Scalia is cited, his opinions are cited much more often in the lower courts than any of his colleagues. Justice Scalia has also been very influential in the academy, both his opinions and his legal scholarship. I was just at a faculty workshop not too long ago that was given by a professor at Georgetown, Larry Solomon. Many of you may know him. He's a constitutional theorist. And he began this recent paper by saying, the most important debate today in constitutional theory is the debate between originalists and non-originalists. In other words, the most important debate today in the academy in constitutional theory is the debate between Justice Scalia and everyone else. If you take a look at how often Justice Scalia's law review articles are cited in the academy, he's number 4 among Supreme Court justices in how often his law review articles are cited. He's behind Oliver Wendell Holmes, Felix Frankfurter, and William Brennan. It's pretty good company to be in. I am currently engaged in an empirical study of how often our constitutional law casebooks cite Justice Scalia's, or not just cite, but include in the casebooks excerpts from Justice Scalia's opinions versus those of his other colleagues. And although the study is not yet done, the initial data suggests that Justice Scalia, again, will be shown to be right at the top of the list of how often his opinions are included in our constitutional law casebooks. And so I think the record is very clear. To the extent we have data, Justice Scalia has been incredibly influential. Part of that, as I said, is the power of his ideas. Originalism and textualism are very powerful and elegant ideas. But part of it is also, of course, his writing style. And I want to share with you a little bit of my own observations from being one of his law clerks about why I think he was such an effective writer. He had a very well-developed method to his writing. First of all, he was a very careful writer, and I want to echo something that Cannon said a moment ago, and that is before he would release any opinion, he went through this very elaborate process called booking. Now, Cannon said that the Supreme Court Library would put together a cart of all of the sources that were cited in the opinion, and he would go through the opinion with the law clerk source by source. I don't remember the library preparing that cart, Cannon. I remember preparing that cart myself, but...
Brian, you got to learn how to tell it.
Yeah, I don't have the same influence as Cannon does over at the court, clearly. But we would sit next to the justice on his couch for hours as he read line by line through those draft opinions. And God forbid, if you had said something in the opinion or cited something that was not reflected in one of those sources, I mean, it was not a pleasant experience. But he was so careful, and you know, it's something that I think all of us should try to recreate in our own work as lawyers, as scholars. You know, we all rely on other people to do bits and pieces of and to help us with our writing. And having us sit down with him at the end, where he would basically be checking our citations, was a very powerful incentive to do it well the first time. And so I think it's something that I try to emulate in my own work when I rely on research assistants and what have you. I thought it was a very careful way to write. The thing that struck me the most, though, about his writing process was that he once told me that he did not write for the eye. He wrote for the ear. He wrote all of his opinions and other works as if they were speeches. He would read them aloud, paragraph by paragraph, as he was drafting them, to make sure they sounded good when delivered orally. And I think the result of that is his opinions were very punchy, very easy to read, because he was writing them like they were speeches. I think it was a very effective way to write. And it's something else that I think we can try to emulate in our own writing as scholars, as professors, what have you. On this point about writing as if what you are writing is going to be delivered as a speech, I do want to say a final word about what I think are the best examples of Justice Scalia's writing, and that is his collection of speeches. His opinions are fabulous. We have our favorites. His law review articles, his books are terrific, and we have our favorites there as well. But I think he did his best work in his speeches. A year before he passed away, I was in his office, and I was trying to persuade him to interview and hire a Vanderbilt grad as a law clerk. That didn't succeed. But one of the things that he told me a year before he died was he wanted to write one last book. And that was a book collecting all of his speeches. And he did not have the time to do that, and I'm sorry about that. I hope someone picks up that project, because I really think his best work is there. And just to give you some examples, in his speeches, Justice Scalia, in his opinions, he was not afraid to take on his colleagues. But in his speeches, he was not afraid to take on the Pope. Some of his best speeches are, giving his views on how one is a good Catholic. He has a very provocative speech where he takes issue with some of the Pope's views on the death penalty. He has another very provocative speech where he explains that Catholics have no moral religious obligation to vote for government programs that help the poor. I think his best work is really in these speeches, and I do hope that someone picks up that project. I believe there's about 60 speeches that he had on his shelf before he died, and I think someone needs to collect those and put those out so we can all remember what I think are his best words. Thank you very much.
And you're the guy to do it, for sure. Thank you. It's really humbling to be on this panel on Justice Scalia's voice. This is your concurring in part, dissenting in part of the program. Voice and vote both matter to the legacy of a justice, and I am certain that he's going to leave a footprint in both. But I'm going to talk about two ways in which the footprint might in other ways fade a bit due to important vote and voice limits. But I want to honor him today and add a voice of sadness at what I think he didn't do and likely couldn't do. Voice and vote are inextricably bound up together. You've heard that. And the better the writer, the more true this becomes. Scalia was exceptionally talented. So his substance was bound up and revealed by his powerful voice. And actually, I think his voice was his vote and vice versa. And the ways in which we agree about so much of this, I think, is also a testament to his coherence. People agree about most of the things that made him powerful. 7 features. First, that transparency and cohesion. Some people can't reveal substance and self so well in writing or so cohesively because they're just not that good a writer. They can't express so accurately, let alone memorably, their commitments. And his writing was so tied to who he was, narrowly tailored, he might say. The envelope was tight. It was a Versace suit, he would say, not a garb made by Omar the tent maker. And the transparency and cohesion, one of his favorite lines, of course, that wolf, this wolf, Justice Scalia, also came as a wolf. He was able to cut a clear path that enabled his analytical coherence to shine. A theory did run through it. He had an above-the-fold commitment to public meaning originalism as a tool of constitutional interpretation. You know that. He preferred rules over standards and formalism over pragmatism. And he had specific substantive analysis and commitments that he was able to draw from his masterful command of all of the law and his own work. This is much harder than it looks for judges or any other writers. And of course, the lucid, punchy writing made the clear analytical strokes bolder, easier to follow, more convincing to some, memorable for all, quotable, and thus a bigger impact. Again, voice and vote, endurance and legacy go hand in hand. His specific normative commitments were fortified by that voice. He admonished the reader, dared you not to listen to him. His defense of liberal democracy was coupled with that Scalia-esque attitude and underscored by that style. Look, he seemed to say, you have to gird up your loins, Massaro, and take your punches in a liberal democratic order. The Constitution is not for the faint of heart or for crybabies. You need to have civic courage, he wrote. He reminded us that voting was once done in public. He would have no problem with ballot selfies, not this guy. His writing voice just dared you to disagree. The short, verbless sentences, the lack of throat-clearing or conditional uhs. It was, this is it, full stop. And his rigor, much talked about by people who knew him better personally, well, it came out even to those of us from afar. In matters of text and unpacking of arguments, there was no applesauce here. There's an opinion I commend to you, Republican Party versus White. If you want to see how to do strict scrutiny, that's how. And that's what I tell my students. This is how you do it. And if you want to be ready for it, you have to be ready for him. Brillo pad, rigor. Statutory interpretation, we're all Scalians now, it's been said, and his good friend Justice Kagan just said when she was at the University of Arizona recently, I think it sums it up. He really just moved the whole field. More on that later. I disagree about the poetics. Early in his career, he wrote a case that I love, Crawford. It has to do with the face-to-face confrontation of a witness in a criminal case. He was occasionally able to summon up lyrical romanticism in service of procedural values that protect the accused, and I loved that about him. I wanted more of it from him. Then, he had the gift of lexical surprise. It was arresting. He was never stale or wrote, jiggery pokery. What? You know, we all have our favorite, what? Surprise quip embedded in an opinion, and it revealed the sixth thing about him is that this man was funny. I mean, often really, really funny, and that was part of the lexical surprise. Most lawyers, most law professors, judges' humor is unintentional, right? Humor's disruptive. It creates a space for union. It rouses the reader. You know, and even his footnotes could awaken mirth. I mean, really. Okay, so we paid attention and we remembered. And last, that verve. He was so unafraid. The Wall Street Journal once called him delightfully brutal. He pounced on words and arguments, lawyers and fellow justices. He did not suffer fools lightly, and he saw a lot of fools. You had to be on your game, awake, armed, and unflappable. Now, if we want Americans to both grasp and care about the third branch, and I do, Justice Scalia's voice brought it to life in ways many other justices did not, do not, cannot. Impact, bottom line, we all paid attention. I started teaching shortly before he joined the court. He was in my head for 30 years. Most of my thinking, more of it, planning, writing as a teacher and a scholar was done with him in my mind than any other justice. I worked very hard for him, trying to teach my students in a way that were he sitting right there, he would say, hear it, well, Massaro, You may be a foolish liberal elite who signed on to the homosexual agenda with all of the fuzzy-mindedness and arrogance that comes with that, especially your irresponsible, undemocratic penchant for judicial imperialism, casting aside all pretense of neutrality. I'm almost quoting everything. But you did accurately and fairly present that case and correctly express my points in it. I worked really hard in the hope that that is what he would say. Because you know what I appreciated? You can't play handball against a curtain. You can't. Justice Scalia was a formidable backboard. But here's the dissenting in part. I think there was a downside. With all due respect to his voice and his vote, I think he was one hand clapping. The missing hand is revealed in the same list I just gave you. The same list I offered in his favor. And I think it will be missing in his footprint too. 1, statutory interpretation. Text-only methodology reigns, but it ignores or completely ignores, downplays legislative history. He won, but no decent lawyer or judge ignores that history entirely. They still argue it in their briefs. I just read one yesterday that was filed in your court. And they commend the legislative history to you. More fundamentally, though, methodology, his methodology, what I respect so much is he tells you where to start. But for me, at least, Justice Scalia was ready to stop a sentence where others would see more nuance and have to continue unassisted by him. Public meaning originalism, I think, is like that. As others have noted, he was a great Old Testament justice, really great. New Testament? He once told me, probably many of you, the problem in the Catholic service came when it was translated from Latin. He said when the congregants understood it, they started to change it. I thought, and I looked again, and he wasn't kidding. So I think it was really good at aspects of 1789, but I've been obsessed with 1865 and 1868 and 1870, those framers too. John Bingham, John Howard, and Thaddeus Stevens. And I think we need to really think seriously about January 20th, 2017. More fundamentally, looking backward helps, but it's not going to help you in a world hurtling forward. History, the historians tell us, lawyers. History is where you look for questions, not for answers. So insisting on looking at history for answers doesn't help the generations to come. It's a retreat into history, that mass still in Latin problem. And it is a problem. And again, that uncompromising voice reinforced the limitation. He'd put the period at the end of the sentence when the hard questions started. And here's the thing. Ideas are much easier to capture in words when the events are frozen in amber, rather than in real time while morphing, hemorrhaging. And opponents' ideas are easier to dismiss if those ideas are not fully engaged or the authors are reduced to cartoons or worse. And that leads me to the delightfully brutal voice. Gird up your loins. Get over it. Okay, what's that missing? Nobody wants to talk about because it's been ushered out as a legitimate thing to think about in our judges. But what's missing there, not in him, but in that aspect of his writing, empathy. And everything I've read, and it's a lot, trying to capture what wisdom is, empathy is always there. Not sympathy, they're not coterminous. Empathy's a pathway to persuasion, better arguments, and outcomes that can comfort the inevitable loser, and to reconciliation. And I think that Justice Scalia's voice sometimes violated that principle. Legal philosopher Martha Nussbaum has illuminated it brilliantly and distinguished between act-based shaming and person-based shaming. I'm afraid he did stoop to the latter to conquer at times, especially when feelings ran raw in the cases that he cared about most, but others did too, and especially in his speeches. Just a few lines you're familiar with, describing opponents as straining to be memorable, egotistical, cannot be taken seriously, engaging in faux judicial modesty, or my non-favorite, the mystical aphorisms of a fortune cookie. That's not a compliment to the person who wrote the opinion. Or my personal favorite, non-favorite, to the Manhattan Institute amidst an appreciative crowd after Romer. My court struck it down as unconstitutional under, I don't know, the homosexuality clause of the Bill of Rights, or whatever that is, and it got a big laugh. Some people thought this was courageous. I think that reaction to a statement by a sitting justice of the highest court in the land is dizzying. So we paid attention. I paid attention. I pay attention. But many also recoiled. And I'm not going to miss the delightfully brutal passages in the least. I'm still unclenching from some of them. On humor, listen, I love funny. I grew up in Wisconsin, where, as in nearby Lake Wobegon, Vicks Vapor Rub is a sacrament. That's very funny in Wisconsin. Dry, rueful humor is essential. That's how we get through the winter. It's very Eeyore. Oh dear, winter's coming. Why do we live here? Thank God for the Packers. But humor has multiple uses and effects, and its context and its author matter. I can mock Wisconsin. You cannot, unless you're from Wisconsin. Judicial humor is dangerous. It's inevitably an instrument of power. Humor in the midst of great conflicts can boomerang if it's not exercised with humility and tenderness. And I think here, as I do so often, of President Lincoln, who mocked himself, not his opponents. I want God on my side, but I need Kentucky. As a young man, he was callow, but not in the job. I've read as much about Lincoln and his speeches and his writing as I've been able to. And the features, including in his humor, is self-mocking humility, empathy for critics, transparent self-doubts, and tenderness. And I didn't hear that. I didn't know him. I know how much he was loved. But I didn't hear that self-mocking humility or tenderness in Justice Scalia's witticisms and barbs in some parts when aimed at his ideological opponents. His voice there was a pugilist, fist on the table, not a better angel's voice, not a Reconstruction house divided cannot stand voice, a voice that is sadly too much in vogue these days. And as he might say himself, too bad. And the points we all give him for laughs in the courtroom, and we do, and he wins. Justice Kagan says she's underperforming. You know, it's a good thing to laugh in the courtroom. But you know, we can't measure winces, can we? Or oof, or wow, or I guess he doesn't have any interest in talking to me. I have had many students, I've been teaching for 30 years. I've had many students over the years come up and ask, am I supposed to talk like that? I said, no, you can't, in fact. Not in here, not in your briefs, not at all. That part of it. The rest of it, that'd be great if you could talk like that. So, voice and vote leave a mixed legacy. On the one hand, more than any colleague, more than any who've ever sat on the court, he brought sparkling intellect, romanticism about liberal democracy, verve and wit to the job. He was the master of the memorable one-liner. On the other hand, some of the memorable lines hurt. He might have brought more of the voice and table to construction, empathic engagement with his adversary's best arguments, more of the wit in service of binding us, written more sentences that went on to address the virtues of the counter-arguments and the people who hold them, instead of occasionally ending his sentences and his opinions with a premature period, and it sounded like rhetorical self-assurance that comes from waving one's hand or pointing one's quill dismissively at others with whom one disagrees. But above all, I wish he'd spent more of that unbelievable intellectual energy and beautiful writing lighting a lamp toward the future. Just imagine what he might have given us all if he'd done so with his voice and vote. I end with huge respect for him and his manifold gifts, an empathic engagement with a formidable justice who lived in a major part of my brain that he now owns and yours, and will do so forever, with heartfelt sympathy for his family and friends and his closest colleagues for whom his loss is the most painful, but a promise. I'm going to hold on to his best voice, and I'm going to try to teach to it still, and do my best to meet that powerful vote and voice challenges he offered to all of us, that guy in my head. But I'm going to do so mindful of where I think even his best sentences ran out, and where much more remains to be said. And that, remember, one's opponent is not the target, only her arguments. And both she and the arguments deserve respect. In particular, I commend the younger ones among you to engage that hope. And I'll end with saying, I hope you see that this is not pure applesauce and no jiggery pokery. Thank you very much for including me in the panel.
an honor to be here, and it's a wonderful topic. When Justice Scalia was put in this position of speaking last on a panel, he used to like to tell the story of the poor junior congressman or woman who had listened through a morning's worth of speeches about this or that bill. It was finally his turn to speak, and he acknowledged that everything that could possibly be said about this topic has already been said, but not everyone has said it. So that would be Jeff Sutton's turn. I have a really amazing 10-page speech, which I'm not going to deliver. I really enjoyed Professor Massaro's remarks, which I heard for the first time just now, so I'm really going to start by talking about that. It reminds me of one of the great virtues of the Federalist Society. In fact, my first Federalist Society meeting was when I was State Solicitor of Ohio, and I was defending a school funding case, and came here and had a debate, and there was a fellow on the panel who's an attorney general of a state named Bill Pryor. I'd never heard of the guy, and and Bill gave, in his characteristic way, a pretty clear-eyed view of why these cases were insane. I had been defending these same cases for Ohio, so I understood the argument why the state courts shouldn't get involved. But I tried to make what I thought was a pretty nuanced point about, well, you know, at least the U.S. Supreme Court didn't do it, and could have been worse kind of thing. And Bill got up and said, "You've lost your mind. I can't believe they're letting you defend this case." And then we became great friends. That's the Federalist Society, and I love the reality that every one of these events, every one of these panels makes sure we have all the perspectives, which is just, it's wonderful because we don't have that in so many areas of law. So let me start by answering a couple of Professor Massaro's points, because it's not as if I haven't thought of that and these issues, and it's not as if others haven't either. So one way of thinking about this is, did it undermine his influence? You know, a lot of people thought he'd be Justice Brennan from the right. It became clear pretty quickly that he was not a counting to five type of justice, and that was never how he was going to be. That was not how he thought about the law. It was about ideas, reasoning, not power. But is it possible he not only didn't have the counting to five attitude, but that he actually lost votes, turned off colleagues, led to outcomes that would not have happened but for the vigor of his writing? Well, first off, that strikes me as a highly uncharitable view of all of the colleagues with whom he served from 1986 to 2016. I mean, it's really an astonishing concept to think there was a justice who ever served on the U.S. Supreme Court who changed a vote based on a hurt feeling. So I think that seems quite unlikely. I sure like to think it's not true, but let me make the alternative argument. If it is true, God help us. If they were going to turn votes based on hurt feelings, what else were they going to turn votes on? So this is not a person you could deal with anyway. So I'm not sure I think too much of the changed votes theory. I don't really think that's fair or accurate. What I think is fair about Justice Scalia, and I think what he would have taken deeply seriously, is to judge the writing on its own terms. If the adjectives, the adverb, if the analogy was too strong, too hurtful, that it undermined the credibility of the point he was making, well, then he should be judged to have not written the opinion as well as he could have written it, and he would have taken that very seriously. But I'm pretty confident most judges and justices over American history would be pretty happy to be thought of like Justice Scalia when it comes to how they used analogies, adjectives, and adverbs, and whether they went too far in terms of undermining the credibility of their opinions. I, for one, it wouldn't bother me too much if that was part of my eulogy. He wrote like Justice Scalia. The third thing I would point out, which is just so, you just have to know the man, and it proves why the golden rule is not the perfect way to assess human behavior, but he followed it when it came to his opinions. There's nothing he liked more than a justice coming back at him aggressively with in response to what he had said. In fact, I think if there's one thing that really frustrated him in the court, it wasn't outcomes. It was when his colleagues did not engage him with respect to the ideas he was expressing. Justice Souter, after Justice Scalia's death, told me this wonderful story, and he told it in a very fond way. It's a classic story. After someone dies, Justice Souter gets the upper hand on the story, and Justice Scalia is not around to defend himself. But it's sufficiently believable that I'm going to tell it to you. And the gist of it was, I think Justice Scalia was writing the dissent. Souter had the majority opinion. Justice Scalia wrote a draft, circulated to the court, where apparently, this is shocking given the booking process, he had misapprehended one part of a Chief Justice Marshall opinions. They were debating some Chief Justice Marshall opinions. Souter, licking his lips, quickly recirculates the draft majority, taking Scalia to task. And the story is, as soon as it arrived on Scalia's desk, he prints it out, grabs it, races into the Souter chamber, says, "Where's David? Where's David? Where's David?" And then he finally gets into Souter's chambers, goes, "David, you got me right between the eyes." And really big smile on his face. Justice Souter, showing his affection for Justice Scalia, told me, I think, given the honor of battle, that he didn't change the lines. And I said, "Really?" And so I went and checked. He did change the lines. And I'm not going to tell you the opinion, but there's a very understated way in which he does it, where he's acknowledging Souter, but not the mistake. So you have to love him for it. So, he followed the golden rule, and he expected others to do the same. Back to my speech, which of course I don't even know where it is now. Let me just make a couple quick observations, and what time do we have? Make sure I don't mess this all up. I did clerk for Justice Scalia, but I was hired by Justice Powell, who was a retired justice at the time, and each retired justice gets one law clerk. I was it that 1 year, OT 91. And the custom at the court is the retired clerks get to sign on with an active justice's chambers, which allows me to say Justice Scalia did not pick me, I chose him, which is a pretty nice thing to say about an Ohio State graduate. You have to say something. So why did I pick Justice Scalia? Well, I'd love to tell you that fresh out of Ohio State Law School, I picked up his theories of textualism and originalism, and we were on the same page, and that really was not it. I was, of course, like most law students, I gravitated to his opinions, and all I really wanted to do was to learn to write like Justice Scalia. But the point of that story is, if you like someone's writing, you're bound to read their opinions, and if you read their opinions, you're bound to learn and understand their theories of jurisprudence. And I think what happened to me has happened to a lot of other people and will happen to a lot more people down the road. One story, we've all told stories of working with the justice on draft opinions, and I have one which says a good thing or two about him and one devastatingly bad thing about me. So I had worked on this one draft, and back then we had floppy disks, and he did a lot of work at home late in the evening, and so I gave him the opinion, and the next morning he brought all of the clerks, 5 with me, being the 5th clerk, and he seemed to be in a good mood, which was good, but I was nervous because I knew it related to the opinion I'd worked on. And he prints out the 8 or 9 page draft concurrence and dissent, and to this captive audience proceeds to give this dramatic reading of the opinion. I had a couple reactions. Reaction 1, who does this kind of thing? Did no one teach you that it's a good idea to hide your pride, not advertise it? And did you not think we had other things to do? But then the second thing was to notice how much joy, the sound, this is Brian's point, that he wrote for the ear, not the eye, the sound of the opinion gave him. I mean, you would have thought he was reading a Shakespeare soliloquy. He was so happy with himself. He was so happy with the language. So one reason he wrote so well is he loved having written well, and he really worked hard at it as a result. The third reaction was, what happened to all my stuff? It's not just spinning straw into gold, it's just getting rid of all the straw. I mean, no thes, no us, no nothing. But most devastatingly, I thought I had come up with this just killer analogy I thought was so classic Scalia and so on point, which was to compare the majority decision to a form of know-nothingism, of course a reference to the 1840s political party, which is quite aptly named. And I just felt so sophisticated having come up with this, and then for him not to leave it in, I just couldn't understand it. So I had the audacity to go in and say, well, Justice, it's amazing, it sings, I love it, blah, 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 but really, the know-nothing line, you had to take that out? And he goes, Jeff, the first reason was you spelled it N-O-nothingism. Nothing indeed. Now, to know Justice Scalia is to want to have the last word with Justice Scalia. To know Justice Scalia is to want to be able to respond when he pokes fun at you. Of course, I just slunk away after he said that, and needless to say, didn't ask any other reasons for not including it. 25 years later, it took me 25 years to come back with a response I should have had that day. Well, you shouldn't be laughing. It's pretty good. You don't know how good it is. So this is what I should have said. But Justice, of course you would always misspell know-nothingisms. That's pretty good. It took me 25 years to come up with it, and that's where we are. So I will finish with one last point. It's a little more sober, but there's one caveat we have to make to the topic of today's panel, which is, of course, writing's not everything. It's true. He wrote like Holmes. He wrote like Jackson. But if that's all there was to Justice Scalia, first of all, I think it would have been largely worthless, potentially dangerous, as proved by Justice Holmes. I mean, Justice Holmes' writing ability did not save him from Buck versus Bell. Indeed, it made it worse, not better. So writing alone is not it. The great gift to the country of 1986 is you had someone with the whole package: thought leader, fearless character, and of course, a wonderful way with words. So thank you.
So thanks to all our panelists. I'd like to ask now if anyone has something they'd like to say in response to what anyone else said, or a question for the other panelists.
I would recount just one more story on this issue of Justice Scalia's tone, and that is this. I remember early in my clerkship working on a majority opinion in a case where I think the vote was 6-3, and we had the majority, so I worked with the justice, prepared the draft opinion, and then Justice Stevens sent around, a pretty fiery dissenting opinion. And of course, being the eager 27-year-old law clerk, my first reaction was, all right, we've got to respond. And so I put a bunch of footnotes into the majority opinion, responding to various things that Justice Stevens had said in the dissent, and I said, Justice Stevens says X, and that's not correct, and Justice Stevens says Y, and that's wrong, and gave the draft back to Justice Scalia. And a few days later, he sent the draft back to me. And he had made a number of other revisions, but he had left the footnotes more or less in place, except for one thing. Every time I referred to Justice Stevens, he substituted in the dissent. And I remember going to Justice Scalia and saying, why did you do that? And he said, because I just thought that it was too personal. And so I do think that Justice Scalia was attuned to that, and he may not have gotten the pitch exactly right in every single opinion, but particularly when it was someone who he had enormous respect for, and I think that was certainly true of Justice Stevens, with whom Justice Scalia had a very warm relationship. He would, if not pull his punches, because Justice Scalia never pulled his punches, modulate his tone appropriately. And in a related vein, the only other thing I would say on the issue that Judge Sutton raised, this question of whether his writing style somehow undermined his influence, is that Justice Scalia was really a master at keeping majorities in cases where he was in the majority. And I think he was very good at writing majority opinions for the court in a way that would keep together the votes from conference. And I don't know how often Justice Scalia actually lost a majority by virtue of the way he drafted an opinion, but I suspect it was sort of surprisingly rarely. And again, I think that was because Justice Scalia was more savvy than some give him credit for. He was not Justice Brennan in that he was not somebody whose philosophy was, we just have to get to 5, and 5 is the most important principle. As Judge Sutton rightly said, that was not Justice Scalia at all. But at the same time, I do think that he had at least a little bit of a pragmatic streak. No, he would not compromise his principles. But yes, he was aware of the fact that it was a court of 9, and when he needed to, he would tailor his opinions appropriately.
I want to say a word about this too, if I may. I think the justice was very conscious of the fact that things that he could say in his opinions would be offensive to people. And it was not uncommon when he was working on an opinion to call one of the law clerks in and to ask, have I gone too far? Now, unfortunately, I don't think we were particularly good sounding boards as law clerks because we're only there for 1 year and, you know, we want to see some fireworks. So I'm not sure we were the best sounding board, but I think he did care about it. I do remember a time when I wanted to add a line to an opinion that said something like, the majority's opinion is like a second marriage. It reflects hope over experience or something like that. And the justice didn't want to put that in because too many of his colleagues had been divorced. So I think, he was conscious about it. But I do agree with Professor Massaro that I think reasonable people can definitely disagree about whether the justice sometimes went too far. He was not perfect. He was the first to admit when he did something that he shouldn't have done. And I think reasonable people can disagree about whether some of his opinions, I think especially maybe his dissent in the Obergefell case, went too far. But I do want to say that as a general matter, I think there was a method to his provocative style, and the method was, I want people to pay attention to my ideas. And this is how I get attention for my ideas, and further my ideas is by writing in a way that people are eager to read what I say. And I know for many of us, but even for many of our friends who are not sympathetic to Justice Scalia's ideas, they tell us that when the Supreme Court issued a decision, many of our friends on the other side would turn to Justice Scalia's opinion first and read what he had to say. And I think that's exactly what he wanted. And, reasonable people can disagree that sometimes he went too far.
Brian's line about second marriages would have been perfect if Justice Douglas had still been on the Supreme Court.
Okay, well, we have a few more minutes left in our panel, so if there are questions from the audience. Surely, there are thousands of you here. Surely somebody. Oh, yes, they're in the back. And we have microphones stationed throughout, so.
Yes, thank you. My name is Briard. I'm a French Supreme Court attorney, and I'm the chair of the Paris chapter of the Federalist Society. I just wanted to tell you, as a European, that we also miss very much Justice Scalia. I met him the first time in 1993. I knew nothing about the American judiciary, and I learned everything from him. And then he became a friend, and this is my first trip to America without seeing him in DC. I wanted to tell you something about Justice Scalia and Europe. Justice Scalia was a great American, but before being an American, he was an Italian American, and he was a Sicilian American. And about my country, about France, he told me one day, there are two major books in my chambers. The first one was written by your compatriot, Montesquieu, The Spirits of the Laws, and to him it was a very essential book. And the second one is La démocratie en Amérique, Democracy in America. And I think he knew a lot about European thinking. And also he told me one day, which is exactly him, he said, Francois, there is no difference between our countries because I know your country was America's first ally. There is one difference about cheeses and religions, because in our country we have 300 religions and 3 cheeses, and in your country you have 300 cheeses and 3 religions. Thank you.
Are there others? Questions for our panelists? Really? I've never seen 1,000 people be so quiet. Well, I had just a thought. We talked a lot about how Justice Scalia's colleagues responded to what he had to say. I think maybe what Professor Massaro was trying to get at was that, but also what his effect on the general public was. And that, I think, is where Brian said that the law clerks could be most helpful to him. And I think that is really something that he wanted when the law clerks were there and able to give it. It is a formidable task to stand up to Justice Scalia and say, here, I think you have gone too far. I think, though, that he really valued it from his law clerks when they would do exactly that. There was one time when he had written something, and I just thought the tone was a little over the top. And so I said to him, I just have a question here. The question is, who are you trying to persuade? The people who already agree with you or the ones who don't? And he, was taken aback and his usual bluster. And then he came back, he took it back to his office, and he came back and he said, how's this? And he had, toned it down a little bit. So I think that is where the law clerks could be instrumental, and I think that is something that he really valued from his clerks. He was sensitive to those considerations, but like all of us, he had his own perspectives, and he needed to have that brought out to him, and he was very, very respectful when you did. Well, after consideration, he was very, very respectful when you did. Do we have any further comments? Rachel, yes. Okay, so the question is, how did Justice Scalia interact with his colleagues? Did he try to persuade them one-on-one through informal communication or just simply through passing memos through his writing? And I will let one of the panelists speak to that if anyone has anything to say.
I mean, he would go down to his colleagues' chambers to talk to them one-on-one about particular cases fairly frequently. It was certainly not uncommon. I think they all did that to some extent. He was very personally popular with his colleagues. People liked him. He was a very likable guy, and he would discuss the cases with them and try to talk some sense into them.
Yeah, I would say overall, I think there's less of that at the Supreme Court than many might think. The Supreme Court really does operate like 9 little law firms, as has often been said, and it's kind of remarkable when you come to the institution from the outside how much of the communication is done the old-fashioned way through memos and draft opinions that go back and forth. I was a law clerk when William Rehnquist was the Chief Justice, and he held pretty efficient conferences, those meetings where the justices would discuss the cases and then vote. He was not a big fan of extended discussions, and so at least in those formal discussions, there wasn't really a lot that took place. And there were informal discussions from time to time, but I think Justice Scalia was, pretty respectful of his colleagues' autonomy. And so, I don't think that he would just wander down the hall scrounging around for a fifth vote in an otherwise garden variety case. I just don't think that he did that, and frankly, I don't think very many of the justices do that.
I was going to echo Cannon's point. Not as much of, not, it's not.
Oh.
That's why they've been speaking all the time. I echo Cannon's point. Not as much of that happens as you might think. Having been a judge now for almost 14 years, I can kind of understand it. It's just not an easy call, right? I mean, you are walking into someone's office. You feel quite strongly about something. You don't know where that colleague is, how much they've prepared to talk about it. Pretty soon, those conversations can get to a pretty difficult place. What you really want to do is be in a position where colleagues are calling you. is really what you want to hope for, because obviously they've got an open mind if they're calling to ask your thoughts. So I think that's actually usually the more effective way to go, and I think that's what most people do.
You know, in the times that I saw the justice do that, I think it was less about trying to change someone's vote and more about shaping what the opinion would look like. That he would want something taken out, or he would want something put back in, and he maybe didn't want to put that into the memo that might be seen by others. And so I think, there's not a lot of vote changing, but I think you can maybe have some influence on what comes out of the next draft.
I have to say, I don't remember too many calls or meetings where Justice Scalia went to one of his colleagues and said, I'm really not sure what I want to do with this case.
We have a question here in the center.
When I clerked for Clarence Thomas, and so we were at a very disadvantaged. And according to the New York Times, we didn't even know how Boss was voting until Justice Scalia came and had a meeting. I do want to push back, though, on this question about some of the more acerbic language not having an impact on the relations on the court. I was there in 96, 97. There was still some lingering but palpable freeze or frostiness from still the outgrowth of the Planned Parenthood versus Casey decision. So much so that when we did our end-of-year skit, we designed it around a fight between Justice Scalia and O'Connor on who's going to drive the bus out to the Ninth Circuit. It had to be a double-decker bus because Justice Ginsburg was on the upper layer. It had to be a bus, not a plane, because Justice Souter didn't want to fly. But there was still that tension about who was going to drive the bus. Did that, some of you that were there in those years in the early 90s, was there that iciness, or was that just something that the clerks kind of erroneously perceived?
So I clerked OT 94, and that was a long time ago, so maybe my memory is false. But I don't remember an iciness between and among the justices. I really remember them being very collegial and very respectful of each other and genuinely getting along. Maybe it's because it was a contentious term. We certainly clerked in a contentious term. It was Lopez and Adirond and the term limits decision, and a number of big cases came out. And so certainly the legal discourse, that there were sharp disagreements among the justices on how those cases ought to be resolved, but everything I witnessed in terms of their personal interactions was really quite friendly and sort of marked by goodwill, and I found that to be very, very heartening.
Yeah, the thing I would say, I was there for OT 91, so that was his second worst term until the Obergefell term. So he was, needless to say, not happy. But there's the short-term reaction, there's a long-term reaction, and the long-term reaction was always, Justice Scalia's perspective. Very good people can have very bad ideas, and I think his colleagues realized it wasn't personal, it was just deeply felt. That was all that was going on, and you have to say, it's not as if the stakes weren't high. Would you really have wanted a justice that was going to take some of those losses, like, oh, well, maybe we'll win next time? So it's understandable why he cared deeply about those cases. But I'm sure there were short-term reactions by all colleagues. They're human beings. Of course they're going to be. But the long-term reactions, I think, are separating the person from the idea. I mean, just read U.S. versus Virginia. He pulls no punches with Justice Ginsburg, none whatsoever. And yet they're celebrating every New Year's together and going to one opera after another. I mean, my God, who could endure that? So I think these were real friendships and real respect, but there's always going to be a short-term, long-term point, and I think the long-term one was pretty positive, and they deserve credit for that.
I just want to say one thing. I didn't say anything about the other justices' feelings. I didn't say that, they changed their vote. I didn't say they were hurt. These are the top 9 judges in the United States of America, and if they can't take the hit, I was talking about something that Justice Larson's talking about. If he was writing to be heard by all of us, then these things, to me, matter. I would be stunned if he and Justice Ginsburg didn't go merrily to the opera. He once said, dashing, what did he say as he was leaving for the opera? Justice by day, dashing young man by night. You know? I said, too, he was loved. Justice Kagan was just at the University of Arizona, and it's still a crushing loss. I don't have any doubt of that whatsoever, and I hope nobody heard me to say otherwise or to imply that these 9 can't take it. I think they can. I was trying to make a larger point.
Okay, we have just a moment for one last question in the back.
I wanted to bring up your comment about the impact of Justice Scalia on the general public. So, of course, we all know that the Constitution and our laws were written not for lawyers or for judges, but for our republic. And I think that Justice Scalia, perhaps more than any other current, or I should say recent Supreme Court justice, really popularized very important constitutional principles for the general public, and that perhaps his greatest legacy will be the knowledge in a broader setting, in a broader world of those ideals and ideas. I myself am not an attorney, but took his course on separation of powers, and I think that that's a great example of the kind of impact that he had in his career.
All right, thank you very much. With that, we are concluded.